So, in fact, the title of the talk that was given to me was, which I have prepared, was Effective Enforcement, a New Instrument for Collective Redress. And I have turned that into a question because I think that is at the heart of what we need to be considering when we look at the proposed directive. I can answer that question very, very simply. You know, will the new directive, the proposed directive, lead to more effective enforcement? Well, of course, the short answer is, I don't know. And none of us know. And you're all looking very relieved that perhaps my talk is going to be over very quickly. But unfortunately for you, you're going to have to stay a little bit longer because I'm going to go into a lot more detail. But, you know, the question of whether or not it's going to be effective, it depends on a number of factors. It depends on, you know, where we start from in terms of assessing it, the context, the data that's available, and how we measure, and what the variables are that are inherent in any event between the member states. So rather than giving you the short answer to the question, what I'm going to do is to give a little bit of context. I think that is important. I think it's really important to understand where this proposal has come from, not just in terms of the report on the recommendation that is relatively recent, and not just in terms of the current policy on the New Deal for consumers, but also the longer story about collective redress and the discourse on collective redress in Europe that dates back some 20 years. I'm not going to go into too much detail, but I think it is really important to understand how we've got to where we are today, because I think that that has shaped what is in this proposed directive. I'm then going to talk about the provisions in the directive, which we've already seen from Martin, broadly what the shape of those are, but I'll engage a little bit more in some of the questions and concerns on the detail that I have, and then try and evaluate it in terms of trying to predict what the effectiveness might be in the light of the aims and objectives. And then finally I will draw to a close with some conclusions. I'm intending to speak for just under an hour, and there will be 15 minutes for questions after. I may be a little under an hour, I may be a little over an hour, but we'll make sure that you have time for questions. So first of all, in terms of the context, I think we should start with the definition of collective redress, and this is one of the areas where I have a fundamental concern, because I don't think there's a uniform understanding of what we mean by collective redress. The Injunctions Directive, which obviously is currently in force and forms the basis essentially for the proposal on collective redress, the Injunctions Directive defines collective redress as measures which are aimed at the protection of the collective interests of consumers. That's incredibly broadly drawn, and it doesn't actually mention specifically redress that would go direct to consumers. And I think if we talk about the meaning of the word redress, it should mean putting the consumers back into the position that they would have been had the harm not occurred, but that too is also open to a number of interpretations. And there's a negative concept of collective interests also set out in the preamble to the Injunctions Directive. I think it's very important to note the distinction between collective interests and collective rights when we're talking about collective redress. And if we look at the recommendation definition of collective redress, it's quite different to what we find in the Injunctions Directive. It references other definitions within the body of that measure, but broadly it's about a procedure that allows two or more people to join together to pursue their legal rights. And the recommendation obviously applies specifically to legal rights, rights arising under European Union law. So we've already got a number of disparities in terms of what we mean by collective redress just in these provisions. And I think that's problematic. with reference specifically to the recommendation, the idea that a collective redress procedure is two or more people joining together, and in a mass harm situation, which is also referenced, mass harm being defined as harm to two or more people, I think anybody who's been involved in any kind of litigation practice in any jurisdiction will be familiar with cases that involve two or more parties. Certainly in my experience in commercial litigation, I don't think I ever worked on a case that had less than two parties. So there are, if that's how we define collective redress, there are collective redress procedures in every single jurisdiction in the European Union. Every civil justice system has a means of joinder or other ways of dealing with cases together in a collective way, if that's what we mean by collective. So in civil procedurals, I think and regulatory models, we also get a number of other concepts of collective redress. And I think really this confusion has to be related to the way that the debate has progressed in the European Union and in the Commission consultations. And I think my perception is it's down to the deep antipathy towards US class actions. And you'll notice if you read the proposed directive carefully that it doesn't actually reference class actions. Virtually none of the materials in support or that have collected evidence or looked at the issue and on which the Commission has relied in putting together this proposal, the words class action are not mentioned. And I think that's political, and I think it's a reflection of the force of the lobbying from vested interests. And so we've fixed on this term that is a bit more palatable, collective redress, but I think it's deeply problematic because we fail to grapple with actually what it is that we're talking about, what is the problem and what is the solution. If we look at the recommendation, it looks like the solution is something that we've already got in virtually every single jurisdiction, but then if you strip out the class action features, such as preclusion and the binding effect of the judgment and opt-out proceedings, so where you have thousands or millions of people harmed by the same event or the same breach of the law, that you have a mechanism where the law can actually achieve finality, make a determination, and put an end to those disputes, which is in the interests of business as well as consumers. But because those issues have been stripped out, I think we've been left with something that is quite malleable at a very fundamental level before we even come on to the provisions of the proposal itself. Just on the issue of class actions as well, I should mention that it's quite interesting to me that there's very little drawing on comparative examples, whereas in previous consultations there's been a lot of reference to the US class action, sometimes often misrepresented, but also to the Latin American models, and I think they're very useful. I would urge anybody working on policy in this area to have a look again at those two different approaches to this problem. The Latin American model has been, there's quite a coherent approach to it, I would say, through many Latin American states, dealing with the concept of diffuse and homogeneous collective actions, diffuse being more akin to the idea of the collective interest, in other words, where you don't have a divisible collective, whereas the homogeneous is more akin to claims aggregation, where you have a number of individual claims that are very similar, that have been bundled up for economy and efficiency purposes to be dealt with in the same process. And the Latin American model, I think, is particularly useful for civil code jurisdictions. I think the American model, yes, it's problematic, but obviously it has resonance with the common law jurisdictions. So those two approaches together, I think, are still relevant here. And I think the American model, one of the quite interesting things about it is it has this public interest element, and I think that's reflected in the debate on competition damages and antitrust, and whether or not we need a mechanism that allows the equivalent of what's called in the US context private attorneys general. So where individuals have a legal right on their own behalf and on behalf of the collective interest or aggregated rights to bring proceedings that collaterally is effective in enforcing public norms. And that concept is very familiar in the EU context, dating back to Van Gendel and Loos and many cases since there. It's not a controversial proposition that effective private enforcement is beneficial collaterally to the enforcement of public norms, and that the right kind of model of collective redress can potentially be very useful in that context. And that the EU, the Commission initiatives on competition damages and antitrust going back to 2001 actually is the earliest sort of significant policy consideration, and then later on after the Courage and Crean case on competition damages, obviously this becomes a more intense issue, but throughout it is this idea that if we have a more effective, more uniform enforcement system for private rights, that the benefit to enforcement of the norms that are fundamental to the internal market should be achieved. And collective redress has emerged in that context. And there are many different ways to approach it, but the controversial aspect has been two things. One, the legal basis on which that can be done for internal market objectives, and secondly, the ongoing and vociferous anti-class action campaign that I think has rendered a lot of this very difficult to resolve from a political level. And then we have the Injunctions Directive is obviously a result of that line of thought, that the main issue is public norms, the internal market, and achieving effective enforcement collaterally. The main issue when I'm talking about justification for collective measures. And then justice and consumer rights, which is what essentially led to the recommendation, is much more about individual rights, the equivalent to a homogeneous class action, as it would be referred to in the Latin American context, where you have a mechanism for claims aggregation. And the area where this really overlaps is where you have mass harm, scattered loss cases, where you've got a huge number of cases, relatively low loss. The damage to the collective interest, the market, the internal market, is very significant, but it's not so significant financially to individual citizens that it justifies bringing individual claims, and may not even be worth a homogeneous class action, because the damages are just not going to not going to be viable. So there is an area where there's a commonality. It's complex to resolve the issue of the legal basis when measures would be directly targeted at that. But I think it's not impossible, and I don't think that this measure achieves it. So then we have obviously towards a coherent approach to collective redress, which led eventually to the recommendation, but also the Competition Damages Directive. So there was an attempt to bring these issues together and to come up with a measure that would resolve or ameliorate or enhance enforcement in both these areas. And ultimately, I think it's correct to say that that initiative to bring together these different sides of the policy debate and come up with a uniform instrument wasn't successful, because we had the recommendation, non-binding, coming out of that, and the directive on antitrust damages, competition damages. Two different measures doing different things. So in terms of, I've already mentioned both of these, the main collective redress measures in the EU context are the Injunctions Directive and the recommendation non-binding. The Injunctions Directive, I think, is very well known to everybody here, and this is the basis on which the proposed directive will proceed. So qualified entities, approved, regulated by member states, able to bring actions for injunctions in the collective interests of consumers, but no direct redress for individual consumers. And the recommendation non-binding, as I've already mentioned, it's focused on rights arising under European law with procedural safeguards. I'm going to talk about safeguards in the context of the proposed directive shortly, but I also have concerns about the use of that terminology and its deployment in this context. So it was recommended that it should be an opt-in process, controls on funding and costs, controls on damages, reflecting all of the concerns about US class actions. And I think it was widely criticised as soon as it was published because of the way that the ambitious programme of coming up with a measure that would tackle mass harm cases in the EU context and particularly cross-border context had been weakened to such an extent that it was, I think, quite widely thought that it wouldn't lead to very much difference. Also being non-binding and leaving considerable latitude to member states as to how they would implement the measures. So as part of the recommendation, there was a review process required in 2017 and also obligations on member states to collect data and report on what has happened. The review was late, but ultimately resulted in the Commission report in January 2018, which was after the announcement of the New Deal for Consumers policy. So it was already anticipated that something in the report would lead to the justification for measures, further measures, legislative measures on collective redress as part of the New Deal for Consumers. So the report looked at how the recommendation has been implemented across member states. So its focus is on procedural rules and legislative changes, to some extent to examine the practical experience of what's actually happened in member states, and to see whether it's achieved its objectives of facilitating access to justice and preventing abusive litigation. And a key question, whether there is a need for further action concerning collective redress at EU level. In terms of the report evidence, so there are national reports which the questions that were asked were targeted very much at the procedures in place and procedural amendments. There is some qualitative data available under the Bickel report, but as far as I can see, there's no systematic primary data collection exercise that's been central to the report, and I think that's an important omission. I think if we're going to assess how effective a measure has been at achieving better access to justice, we need to know how many cases are not being pursued and for what reason. And I don't think we're in a position to understand that in any of the member states as far as I can see. And I think methodologically that's quite problematic. I think it's deeply problematic in terms of taking a comparative approach. So even if the data is there, We need to be very careful about the language that we use and the definitions. I talked at the beginning about collective redress and how that has become part of our language now when we're talking about these issues and procedures in the European context. But we haven't talked very much at all about the language in the different member states and how different terms are used to describe procedures that might essentially be aimed at the same objectives. The other thing I think that's really quite difficult is confounding factors. If we're going to look at whether or not the recommendation has been successful and whether or not the measures that are being proposed are likely to be successful, we need to understand the wider context as well about economic barriers, about cultural and political barriers, issues such as trust in the justice system, and even practical issues like how easy it is to access the courts or access legal advice. And as far as I can see, those issues are kind of outside the remit of what's being considered at the moment. And I think we need to recalibrate on that and have a better understanding of what the problems are. That will also give us a better baseline to measure going forward whether or not the proposed directive, if it comes to pass, has any impact at all on either the collective interest in public norms enforcement or in private rights and redress to consumers. So despite those what I consider to be problems with the evidence, there was a conclusion that there had been rather limited follow-up from the recommendation. I think that's a fairly narrow conclusion, and perhaps not surprisingly either. Yes, there has been a limited follow-up, but I think that was possibly to do with the fact that the recommendation itself was a rather timid response to, in the face of extraordinary lobbying and pressure mainly from commercial interests, actually. So the upshot of that was the recommendation report proposed further measures which endorses the view that's come through in terms of the impact and effectiveness of the Injunctions Directive and its underutilisation. That has been apparent since about 2008, I believe, was the first evidence where that was identified. So, as part of the New Deal for consumers, as we've heard, we have this proposal on the table, a proposal on representative actions for the protection of the collective interests of consumers and repealing the Injunctions Directive. The aim of the New Deal we've already heard about in some detail, actually, but the important one here is better redress for consumers to support effective public enforcement. And I think also the equality issues, equal treatment of consumers in the single market is clearly relevant here as well, if this is going to have an impact on consumer rights. So I've already talked about the evidence in support. Again, I think even the independent studies like the MPI Luxembourg study was primarily focused on procedural rules, procedural experts, and not on wider issues that might give us some insight into understanding the extent of the problem of under-enforcement and the reasons why initiatives such as the Injunctions Directive and the recommendation appear to have had limited impact, and what further steps need to be taken, and whether or not this proposed directive is actually targeting pointed at the right target. If the problems are caused by a lack of collective redress procedure at EU level, then yes, but I don't think we even know that in terms of the uniformity of the problem across member states. I think we can surmise and we can predict, and it probably is likely to an extent, but I don't think we can say there's a definite causative link. So the proposed directive itself, the objective stated in the memorandum, the explanatory memorandum, is to provide robust, efficient and effective enforcement. Who could disagree with that? And to ensure that member states fully apply and implement and enforce their obligations, and to provide adequate redress for citizens. So that comes as the redress for individuals comes as a collateral aspect to the wider public objectives. And as I said, it's going to modernise the Injunctions Directive, improve the effectiveness of the injunctions procedure, and contribute to the elimination of consequences of infringements and collateral enforcement. So, so it builds on, it's very interesting to me that in Article 1 of the proposed directive, the key sort of stated aim is to set out rules not just about expanding the scope of remedies that representative entities can seek, but also, in Article 1, ensuring appropriate safeguards to avoid abusive litigation. I have real concerns about the perpetuation of this language, appropriate safeguards and avoiding abusive litigation. That comes from the US class action discourse. And as I said earlier, my perception is that many of the terms that reference directly class actions have been stripped out of the debate. And I think that that lobbying has been incredibly effective. But what's been left in as a primary, apparently, aim of this measure is to safeguard, in other words, restrict the scope of the procedure, and a presumption, undefined, that if we don't have tight rules, that there will be abusive litigation. I don't know actually what abusive litigation means in terms of problem. I do understand the idea of an abusive process. I understand the idea of trying to bring a claim that lacks any merit. But in my experience, the courts already have more than enough powers to stop abusive process and to throw out unmeritorious claims at an early stage. That's at an early stage. That's why we have summary proceedings in every civil justice system, and we have mechanisms pretty much everywhere that allow cases to be either determined at an early stage categorically or thrown out because they're baseless. And I think we need to be much more specific about what we mean when we talk about abusive litigation. And we need to be much more specific about what we mean when we talk about safeguards, because these are essentially procedural rules that restrict the scope by which people can access courts, whether they're representative entities acting in a quasi-attorney general capacity to defend the public interest, or whether they're acting on behalf of themselves and or a group of others with similar claims. The other thing I'd say about safeguards generally is civil procedure rules generically are about restricting access to the courts. There is no unfettered right of access to the civil courts in any jurisdiction. And there are inherent procedures available. And again, I think this needs to be looked at very carefully. If we're saying there aren't enough safeguards already to stop abusive, so-called abusive litigation, then we need to be looking much more widely at civil justice systems and beyond class and collective actions. It was mentioned earlier on that there are issues about private international law and recognition and enforcement, and I think that is a concern here with this measure as well, is that there's no advancement in significant terms and tangible terms in terms of cross-border issues specifically relating to class and collective action judgments. And I think there is a reason why that's logical, which I'll come on to in a second, and it's to do with the other provisions under the proposed directive. So in terms of the operative provisions, the ones I want to talk about in most detail are the remedies under the proposed Article 5 and also the procedural modalities under proposed Article 6. So the remedies will perpetuate the injunctions facility that's already been there in the Injunctions Directive, but it adds The capacity for representative entities to seek redress orders, these aren't specifically referred to as consumer damages or compensation orders, although it's apparent from the drafting that it could potentially include those types of measures. But it also is a non-inclusive list of other types of measures, non-monetary measures that could be used to put consumers back in the position if they hadn't, as if they hadn't suffered the loss. But it's left open to member states to go beyond that or to have other remedies available as well. So I think there's some lack of clarity there. I would also raise the concern about compensation, that because this is about acting in the interest of consumers, it's not clear on what basis the quantum of compensation orders will be assessed, whether or not it should be linked to ideas of civil rights and assessment of damages, or whether it should be on a different basis to that. And I think that makes sense. It makes sense in terms of the fact that this isn't about individual rights. The term consumer rights has been avoided. But it doesn't make sense if the objective is to have some kind of harmonised approach to using private enforcement to effect upholding of public norms, and also to achieve aims such as taking out of the market illicit gains. If there's no understanding of what the common approach to assessment of quantum is going to be, then I have concerns that the likely effect is not going to be uniform across the member states. In terms of the proposed Articles 5 and 6, one of the big issues I think that needs further scrutiny and is problematic is the way that the potential for redress orders is subject to derogations and exemptions. So member states can potentially decide that, well, there's a possibility that in complex cases, even where there are many consumers clearly who have been adversely affected, that only declaratory relief would be given. But complex isn't defined, and again, that's from a certainty point of view, legal certainty, consistency, clarity. I think that's extremely worrying, actually. The case that springs to mind when talking about that is actually the Dieselgate case. I don't think anybody could possibly describe that as anything other than complex. On so many different levels, that is a complex case. But it is one of the drivers behind this initiative, and the concern that consumers, so many consumers affected across so many member states, weren't able to access redress for breach of their rights, besides the internal market concerns. So I'm perplexed at that derogation. I think it's a very interesting measure in that it allows for some kind of flexibility, and it doesn't try to create a model that shoehorns everything into the same box. But in terms of harmonisation, I think it's concerning. The other issue that concerns me in terms of redress is that it's open to, it's provided that it should be open to the judicial authority or tribunal making the decision that in cases where there are scattered losses and the individual loss to consumers is disproportionate with the cost of repatriating some form of redress to those individuals, that instead it can be, the funds can be attributed to some kind of public cause. This provision, I can understand the economic arguments for it, But if we're talking about consumer redress and achieving as one of the, not the primary aim admittedly, but one of the aims of this is to improve the protection of consumer rights. And I think the consumer, in monetary terms, is not going to have any redress at all in that situation. I can understand the proportionality argument, but I think that it leaves open the prospect of so much disparity in application, so many subjective judgments influenced by very specific, case-specific factors, and possibly even in terms of the implementing legislation from member states, that it gives a get-out clause to actually put in place a measure that is going to make any real difference. So at the heart of those two measures, the proposed Articles 5 and 6, I think we have an idea that we can see the potential for improved redress to consumers, but not in complex cases and not in cases where the losses are scattered and the value of individual claims is very low. So we have a small category of cases in the middle that is likely to, in my opinion, be further narrowed by or can quite easily be narrowed by implementing legislation because of the subjectivity of the terminology that's being used. I think there are probably, I've got about 20 minutes left, so I'm not going to talk about some of the other procedural issues in detail, but I think there are common themes in terms of funding, how these claims are going to be funded, and how uniformity or some kind of equality across member states and achieving harmonisation is how that's going to happen is I think open to question. And I think we have experience from the UK context of these kind of restrictions on funding, restrictions on third-party funding in collective claims. Well, I'll come on to that in a minute, but I have concerns that we don't have a clear picture of how these cases might be funded, given those restrictions. If we just reference again the benefits of the class action, that are admittedly very problematic, but the US class action, one of the benefits of it is the idea of finality and preclusion, legal certainty, that when you have a class action, opt-out class action that is certified, and then you have a final settlement or award, it precludes those who haven't opted out from bringing individual claims. So we have the prospect of clarity of law and also of finality, which from a business point of view I think is highly desirable. However, because this measure, I assume it's because this measure is not about determination of consumer rights, how could we have finality? How could we have preclusion? And I think that's deeply problematic. I think because this type of measure has been so watered down because of the lobbying, that granting collective rights has become sidelined, and instead we have this idea of a gatekeeper, representative entity acting in the collective interest. But we have principles of justice, human rights, recognition of consumer rights in the Charter and the treaties, and so of course a final decision where there's been no determination or no opportunity of determination, even if it's been foregone by the individuals, it would be extremely concerning if there had been preclusion and final determination on individual rights. So one of the major major advantages of having an effective class action cannot be achieved by this proposed directive because there won't be finality. And also, on the cross-border issue, I think that problem is exacerbated by the way that cross-border applications are dealt with here. So member states will have to recognise the status of a qualified entity to bring proceedings, and that could lead to parallel proceedings. We heard earlier on that it's not an objective specifically to prevent parallel proceedings. So we may see numerous collective redress proceedings being brought in different jurisdictions with different funding arrangements, and potentially different remedies and potentially different implementing provisions that narrow or broaden the scope of what we mean by complex cases and what we mean by proportionality and justification for allocation of redress to public sources, to public ends, as well as the potential for satellite litigation, individual claims from individual consumers, and pursuit of claims under representative or class action proceedings that still exist in member states or have resulted from the recommendation. I think that's really some really quite fundamental issues that might prove problematic in the future. I may be wrong, because as I said at the beginning, I don't know whether or not this is going to be effective. None of us know the answers. So I think I've probably covered quite a lot of these points already. I just wanted to touch for a minute, as I haven't really talked about specific examples of different jurisdictions. That's deliberate because I think the main focus should be on actually what the proposed directive says. I could have given a lot of examples to illustrate the existing disparities, but I think the one example I would like to talk about is the UK damages claims mechanism under the Competition Act 1998. And that's partly because it's quite similar to the idea of a class action. We have we've had the potential for damages claims for some time under the Competition Act, but under the Consumer Rights Act 2015, there's a major overhaul of consumer protection legislation, and Schedule 8 of the Consumer Rights Act 2015 introduced a whole range of new consumer protection and enforcement measures, including the possibility of collective settlements and consumer redress schemes with regulators, but also collective proceedings, opt-out collective claims before the Competition Appeal Tribunal. We'd had prior to that the possibility of follow-on claims in the Competition Appeal Tribunal, which hadn't resulted in very many cases at all. And so this is a really significant piece of legislation amending the Competition Act, and the Competition Appeal Tribunal is a very well-resourced tribunal. It's very sophisticated. It uses a lot of modern technology, so it's not challenged by a lot of the issues that ordinary civil courts are challenged by. And as I said, it's an opt-out procedure. And we have the possibility of third-party funding and damages-based agreements for funding, although controversial as that is. And despite all of that, I think this graph is quite interesting, really, that the number of collective settlement cases that have been brought to the tribunal since the relevant provisions came into force under the 2015 Act has been zero. There's not been one collective settlement case. In terms of the opt-out claims, it's been incredibly low. The data here is from 2004, so it includes cases that would have been prior to 2015 could only have been brought as follow-on claim. So there was, I think, one of the cases was pre-2015 and 4 of them post-2015, and that's it. So even though we have an opt-out consumer redress procedure under a modernised system with a well-resourced tribunal and quite a sophisticated and very experienced consumer rights organisation, which is the approved entity to bring claims. Despite all of that, we've only had 4 cases since this legislation came into force. And I don't know why that is. I can't tell you what the answers are, because, first of all, it's questionable as to whether or not that's statistically significant, that number of cases. Secondly, there hasn't been enough study of this, and I think that's quite difficult to do at the moment because a lot of issues still remain unresolved. I have, however, spoken anecdotally to a number of commercial law practices who were looking with great interest at the Consumer Rights Act as it came into force, and were anticipating that it would be an area where their workload would develop quite significantly. It would open up lots of possibilities to bring collective claims in high value, where the aggregate value was high, so they would become more viable, and that this would, in some sense, give an alternative means to redress to the avenues that have been shut down since we had a quite vicious cutting of legal aid from 2012 onwards that has left a hole in access to justice. So I know that there were a lot of commercial firms looking at this. I know that there were a lot of third-party funders looking at this. And I know that when it first came into force, there was a sense that of watch and wait for somebody else to jump first, because we have no understanding of the way that the tribunal is going to interpret and apply the legislation and the procedural rules. But they kept watching and waiting, and they kept watching and waiting, and there hasn't been enough in terms of cases being brought forward to give much feedback. I think the upshot of it is it's very difficult to see from this that there's a risk of abusive litigation. It's very difficult to conclude from this that an opt-out consumer claims procedure is likely to lead to vexatious or unmeritorious claims. And it's difficult to say whether or not it would be successful because we don't have the evidence to say what the cause of this is. What is the cause of this very low number of cases? I'm sure it's not because there are no cases out there, although I can't say that I can point to any evidence about that. And I think in terms of benchmarking, that legislation is very helpful because we've got a clear date when this new model came into force. We can measure it from then. And also we have data, clear data available that the tribunal has kept since 2004 that we can measure it against. I don't know how we would do that in other scenarios, but I think having a careful selection of tribunals and courts from the different member states that might have access to similar data or similar records, and seeing what impact any changes to the procedural requirements results in, I think is the way to understand whether or not these measures are effective. But it seems to me there's a lot of work to be done just in getting to the baseline so we can measure going forward what the impact is. But as I say, I'm afraid to say that I'm quite sceptical. I don't think that this is this represents a new deal for consumers. I think this particular proposal represents a continuation of the conversation that's been going on for a very long time. And as far as I can see, the laudable attempts to have some kind of consensus on a way forward have resulted in a measure that's very timid, that lacks clarity, that has so many areas of flexibility and discretion, that I think it's highly predictable that we will have continued variability. And I'm afraid to say that I don't know if we are in the position to be able to measure going forward what the impact of this is likely to be once it becomes effective, presuming it becomes effective. And not just in terms of how member states implement the measures in their procedural rules, but in terms of the actual impact on the internal market, on competition, antitrust, and on individual consumers. But I fear that the individual consumer is not going to see much in the way of benefit from this. So I'm very sorry to be a pessimist. I guess on the upside that less litigation means less argument, so perhaps that is the silver lining. But thank you very much. I'd be very grateful to hear some of your observations and questions if you have any. Thanks.